Okay, so I had the hard task to try and summarize the discussion of this afternoon, so it's a tough exercise, and I won't be able to do justice to everything that has been discussed today, so I will propose my reading. I could actually end in 1 minute by having a very short summary, taking the quote by Jorge Contreras saying, let's stop obsessing over hold-up, but I wouldn't fulfill my task if I was doing this. So let me propose trying to answer 3 questions. The first is, what is the problem? What do we mean by patent hold-up? The second is, how serious is the problem? And the third is, how to fix the problem and why. Okay, so what is the problem? What do we mean by patent hold-up? I take here the definition that was given by Yann Menière. It's an unbalanced bargaining power in exposed negotiations. The question was, is it opportunism with guile or not? I leave the debate open here. Let me just give you different forms of hold-up. We concentrated on standard essential patents, but in non-SEP cases, that's the case of patent assertion entities, or whatever the name you call them. If we talk about standard essential patents, well, we should make a distinction between hold-up that would be exerted by the patent holder, patent ambush or unreasonable royalties, are they not friend, but also potential of hold-up exerted by implementer, that would be the reverse hold-up, holdout, or whatever the name you give them. Another way to define what we're talking about is to look for necessary conditions. And here it was proposed to look at, well, first of all, we need patent holder and implementers, a problem of negotiating ex-ante licenses, and some leverage. So patent owner could obtain an injunction for a patent infringement if licensing negotiation fails. People insisted on the fact that we should make a clear difference between SEP on the one hand and market power. These two don't go necessarily hand in hand, and also a distinction between patents conferring market power and hold-up. These two don't go hand in hand necessarily either. How serious is the problem? Well, there is no clear empirical evidence for the main reason that data is hard to find. Most licensing agreements are by nature secret, but some stylized facts exist suggesting that the problems may occur. Most of ICT's licensing contracts are exposed. This is because the sector is evolving very fast, and there is a big need for interoperability. So if there is no empirical evidence, if we want to look for it, or at least build a test, how should we do it? I gave on the previous slide necessary conditions to have an SEP hold-up. Are they met in practice? The view is that they are not really met. Then we should look perhaps at secondary evidence, and here the case is not strong. Price-quality ratio don't seem to be increasing over time, or there is ample entry in these industries. But the lack of secondary evidence is not a real proof by itself. Is evidence necessary? Yes, at least to justify the fact that we spent the whole afternoon discussing about this here today, and so many people were here. So if we multiply the time we spend and the salary we make, or you make, the money can be quite high. So other people say, no, we don't need evidence of a market-wide phenomenon to prove anti-competitive conduct or harm by a particular company, so evidence may not be needed after all. Some people also suggested that the importance of the whole problem may be overemphasized. Is it the result of a lobbying effort? Is it an attempt to shift bargaining power from patent holders to implementers? I quote here. How to fix the problem? Why do we need solutions? Well, people insisted on the fact that in many areas, and the example was given of Internet of Things, predictability is very important. I should add myself that we need to be aware of dynamic effects, not only maintaining incentives to innovate, but also making sure that standards are diffused largely. And it was said in the last panel that standards are important. How should we fix the problem? Ex ante or ex post? Ex ante, making sure that the problems don't occur, or making problems less likely to occur. Well, patent offices are there to maintain patent quality and transparency, which is a sound basis for contractual arrangements. Contractual arrangements can be found ex ante to try and alleviate the problems, like portfolio licensing, cross-licensing, or patent pools. And of course, standard setting organizations are there to try and also alleviate the problem. But there are a number of questions like how to define friend, what is the counterfactual, as Jorge Padilla explained in the last panel. Some people also suggested that the working of SSOs should be better supervised, or third parties should be called for example, scrutinize essentiality. And also people say that the rules of the SSO shouldn't be anti-competitive by themselves. Now, the last point is solving the problem ex post. And there the discussion was about which type of law should be used, IP law, contract law, or competition law. And there some people talked about the fact that there was no articulated theory of harm, also raising the fact that probabilistic context of patents shouldn't be ignored, and also insisting that the possibility of reverse hold-up shouldn't be overlooked. And I must say that I was a bit lost in the last panel because I'm an economist. So I wish I would have been able to say more about on this last slide, but I suppose that lawyers in the room would have understood better than me. So I said 10 minutes is probably less than that. Let me conclude with one word. It is going to remain a heated debate, and this is my last. And I suppose this is also the state all of us are, we are in for the moment. Thank you.